So I have no problem backing that up.
Before you step down, kind of backtrack, but by them getting all of that into her case, is that going to probably impede you in the future because now they have stuff on record in a court case against you?
What I would say is no, because if she would play it right, she would say, you know, this is what I believed until my expert wrote this affidavit, and I really had time to look at this. I was only handed a copy this morning. You know, before I went in, I hadn't had time to properly prepare my case, and now I've discovered that after reading this document, there's nowhere that it says I ever received a loan.
Let me make something very clear here. The concept of being a good litigator as opposed to being a good lawyer is to be able to turn things around. So she can definitely save it. Just like in the Slicker case where the lady, they asked her, did you get a loan? I got a loan, blah, blah, blah. She should have come back and said, oh, Your Honor, I have to alter my statement. I did not commit perjury when I admitted the loan because that's what I believed. But now I discovered I never did receive a loan. So the problem is, Your Honor, not that I committed perjury, because I'm correcting that statement, that I had been so convinced from their criminal acts of fraud, all it proves is that they did commit very, very efficient fraud. But now let me correct the record. So Anita can do the same thing.
Yeah, we know it was her.
Oh,
right.
I don't care. I've already... I've been
wanted
very clear about this shit.
I've read your letter, I've read her letter.
Soon as you did. But look, most importantly, right on number 2.
Quick question about notarization for the MERS deposition and Horner's docs. Do we want to get those notarized before we record them?
What notarized?
The MERS deposition and the Horner docs?
Oh.
Yeah, do it.
I don't know.
Well, the MERS deposition is really already a court document. So yeah, if you wanted to record that, that's great, but you just don't have to. The notarization has nothing to do with it. The recording makes it authenticated because it has a public seal on it. The notarization is really just an acknowledgement. So no, one has nothing to do with the other.
Okay, so you can record them without notarizing.
Yeah, I'm not even sure why people get that confused, other than it's just bureaucratic crap, but one has nothing to do with the other.
Thank you.
Is there any more questions about anything?
Not at this time.
Okay. All right. And
Affidavits are fine. Affidavits are effective anywhere.
Okay.
Okay.
Yes.
If there's a bankruptcy hearing and one has paid for the expert to testify on the documents, when and how would it be appropriate to present them to the court?
In the discovery phase. I'm not that familiar. We don't really discuss bankruptcy stuff here. I don't like bankruptcy stuff. I don't believe in it. But there's a discovery phase in bankruptcy, which actually it's intrinsic to the filing itself. So, you know, if you can start discovery, you can always supply your own discovery to the other side. And I would say do it from the very beginning. Because your affidavit will stop the other side from maybe even trying to attempt the stay. Listen, we had a lot of problems in the beginning here. Why? Because people didn't listen to me, and what happens if you don't listen to me? You're wrong. Sorry, I didn't make the rules. I learned them. That's number 1 rule.
You've been here before.
When in the beginning it's like, I need the title company so we can search this stuff, so we can get an affidavit. Nobody got off their ass and did it. Cindy got off her ass and said, well, we can't find one because every time we find one, turns out they're part of the fraud, so they don't want to be involved. So Cindy got her title abstractor license, plus she's a natural at the document shit. And what's happened since then? Exactly what I told you would happen. We put in an affidavit, says there's no chain of title, these guys are lying, blah, 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 and the banks start insulting us. But they don't fight our evidence. They don't rebut the evidence. They don't go under oath, under penalty of perjury. So what's going to happen? All of our evidence is going to stand. The rest of it's just insults. Insults don't work in court, guys. I know, I've used them. Evidence is everything. Affidavits are everything. we've got them. Since we've started using Cindy's affidavits, they're just going psycho. They're not even. Marty got a freaking TRO granted sua sponte, ex parte in 4 hours, and they didn't even call anybody.
Not only that, John, I don't know how to put it exactly, but they are insulting Cindy to the extent of perjuring themselves in the extent of disallowing them to continue with the case, because now they're going to get sued.
Well, and that's one of the things that we're saying. The attorneys are insulting Cindy. They're saying lies about this group. Here's a problem. Is the attorney saying it, or is their client saying it? Oh, now we have a problem under Arizona law, whether it's federal or state, because Cindy can file a libel suit. Even if she doesn't, she can file a libel suit. All Cindy's got to do is send a notice to them that she may be filing a libel suit, so she wants to know, is it the defendants that's claiming this, or is it the lawyers that's claiming this? And what must the lawyer do by Arizona law?
Quit.
Withdraw from that case, because they cannot witness against their own client. We're done. Yeah, this shit works, and I'll tell you what, it syncs them with the affidavits. Affidavits are everything. You could do cases with affidavits. You'd never hear from attorneys. Never need an argument.
Oh, I can talk on here?
Yeah.
I just wanted to say one other thing that actually discovered, helping me with the research on one of the affidavits. We had a notary from Georgia who was attesting under certificate of perjury, I think, or I forget, there's verbiage in there about I certify under penalty of perjury under California law that all that I'm notarizing is true and correct. She was a notary from Georgia, not a notary from California.
Wow.
But the document was a California document, and somehow they didn't get the right document. So that's
document,
completely invalid, because she's only a notary of Georgia. How can she certify under penalty of perjury for California's law? And that's where she signed. So yeah.
She just confessed to perjury is what she did.
Yeah.
That's
Big
what she
yeah.
did.
Big
You
yeah.
just never know what you're going to find in these things. It's crazy.
Well, and that's in every notary manual that I've read, and I've read several of them, they can't really even notarize outside of the state line.
Right.
You know, you can't cross state line to notarize something. Their notary stops when they hit the state line. They're commissioned by the Secretary of State of that state. Yeah. I don't even know if there are, the only true federal notaries are commissioned officers. And I'm not sure if that applies to all branches of the military. I know that Army officers are commissioned notaries. What's the bank's name, Stephen?
Federal Home Loan.
Okay. We're convening this hearing, federal home loan for, is it a forcible or non-lawful?
Forcible detainer.
Forcible detainer. Again, Stephen, so court is in session. Will the parties please acknowledge?
Bernie Probilski for federal home loan.
Okay. Just for you people on the internet, Bernie is the plaintiff. Stephen has lost a foreclosure. It snuck up on him, didn't know anything about it. Next thing you know, he gets a forcible detainer. They're trying to kick him out of his house. So Stephen is the defendant. So go ahead and acknowledge Stephen.
Stephen Sontig, pro se, Your Honor. Your Honor, before we get started here, we can resolve this matter quickly if the plaintiff will stipulate and admit as to whether or not they are the creditor and the holder in due course.
Okay, well, we're getting ready to do opening statements here.
Your Honor, I move this court to have the plaintiff stipulate and admit on and for the record and under penalty of perjury as to whether or not they are the creditor and the holder in due course.
Okay, I get your point, Mr. Sontag,
With
but
all due respect, Your Honor.
I object, Your Honor.
I move this court to have the plaintiff stipulate and admit on and for the record under penalty of perjury and for my future appeal as to whether or not they are the creditor and the holder in due course.
okay. I'm going to overrule the objection. Now, Mr. Sontag, let me talk for a minute. We're convening this hearing to do a forcible detainer, and we do have certain procedures. So we're going to let the parties do their opening statements. Okay, now go to the, Your Honor, this can't be a hearing because there's not a jury here and I demanded a jury trial. Go into that.
Your Honor, we can't be here today because I believe that the other side does not have standing and that I demanded a jury trial. And Your Honor, with all due respect, again, I move this court to have the plaintiff stipulated admit on and for the record and under penalty of perjury and for my future appeal as to whether or not they are the creditor and the holder in due course.
Okay, I hear your point. We'll go ahead and do the opening statements.
Your Honor.
Just say under my objection, Your Honor.
Under my objection, Your Honor.
Okay, duly noted. Mr. Pabilski, will you state on and for the record whether or not your client is the creditor and holder in due course?
Well, Your Honor, we are here on a forcible detainer. The question of whether
I object, Your Honor.
we're the holder or not isn't even for this court to decide. It's already been decided, Your Honor. We've already foreclosed. We'd like to have our house, Your
Okay,
Honor.
he did object. I'm going to have to put that towards the weight, Stephen. Okay, I'll tell you what, why don't we just go ahead, if you can hold off on your objections. I'll duly note on this court's record that you object to the plaintiff moving forward and this hearing being conducted without a jury, but I've already concluded a jury's not appropriate in this matter. Object right there. Object.
I object, Your Honor. I hereby again demand the jury trial. With all that said,
So, pursuant to what?
pursuant to the Arizona Constitution, Article 2, Section 4, no person shall be deprived of life, liberty, or property without due process of law. Your Honor, you are depriving me of my right to a jury trial. I claim viet armis.
Okay, what about the ARS? You're supposed to throw in that ARS.
Your Honor, also according to ARS 12-1176, demand for jury trial procedure. A, if a jury trial is requested by plaintiff, the court shall
Okay.
grant the...
Okay, Stephen, duly noted. I've already decided there is no jury trial in this matter. Go ahead and object.
Your Honor, according to ARS 12-1176, Section B is...
Stephen, say, I object, Your Honor.
I object, Your Honor.
Okay, I object. I have the right to a jury trial, and you are depriving me of my civil rights.
I have the right to a jury trial, and you are depriving me of my civil rights. It says in Section B of ARS 12-1176 that if the plaintiff does request a jury, the defendant may do so on appearing, and the request shall be granted.
And just say, Your Honor, shall be granted.
Your Honor, shall be granted.
Okay, duly noted. Okay, we're going to do opening statements with no more interference from either party. Do both parties agree to this? Plaintiff.
I agree. We agree,
Defendant.
Your Honor.
No, Your Honor, I don't agree. Because I believe that we shouldn't even be having this forcible detainer hearing. There's no grounds
Okay.
for the forcible detainer hearing.
Duly noted. Duly noted. Now, Stephen, I understand you're pro se,
Yes,
and I understand that you're not an attorney.
yes, that's
But we're going to move forward in this hearing. So, just for the next few minutes, you're going to allow the plaintiff to give their opening statement. Do you agree to that?
No, I don't agree to that.
You're fucking good, buddy.